of the 9th petition. Thank you, my lords.
My lords, I would like to make an application under Article 1.1 directly. My lady. My lords and my lady, we are thankful for your ruling today and the lengthy explanations and court case law that has gone into it. Unfortunately, my lords and my lady, it seems that some people are being favored over us, and in this matter, it is the state or advocates. We are here acting in person, and we are entitled to the same equal protection of the law. We are here trying to defend the Constitution and our constitutional rights. I am being discriminated against as a woman, as a person with disabilities, and as a youth, my lords and my lady. We filed our application on the 8th of October 2024, and we thought that we would be enjoined as interested parties to participate in Tuesday's proceedings, but we were not. So we did not have the time to ventilate our issues properly. My lords and my lady, we are asking you to stay your orders for 7 days, as you have told us to come back on the 7th of November, so at least we get a fair chance, a fair fighting chance as a sovereign to also ventilate our issues properly. The state cannot override us, and advocates cannot override us, my lords and my lady. This is a court for equality, and we are asking for equality. My lords and my lady, we also appreciate that regardless side has asked for 7 days to appeal. Kindly consider us in, because there is no point in justice. It will be granted to some petitioners, and others will just be thrown under the bus and into the darkness. Thank you.
My lord, if I may respond, my lord.
Sorry, just a minute. Can you just clarify your application? You say is dated the 8th of October?
8th of October 2024.
Substance of the application?
It's petition E541 of 2024. We were seeking stay orders to stay the proceedings in the National Assembly based on Article 32(1), freedom of conscience, and Article 33, freedom of expression.
Your Honor, maybe with your kind permission.
Let me clarify. Is that the matter in which you are appearing with Dr. Eboso?
Yes, my lord.
Yes. Now, if you have been following the directions of this court keenly, we have been issuing various orders on consolidation. And I can assure you, I did that. And you and Dr. Bosso are petitioners in one of the cohorts. I think it's cohort number 1. Yes, it's cohort number 1. You are petitioners in cohort number 1. And we directed everybody to get into the CTS system, and whoever has a problem to get in touch with the deputy registrar. So it is not right, Ms. Wanjiru, to claim that you have not been enjoined in these proceedings. You have been enjoined. You are a party, and that is why we allowed Dr. Bosso to address the court, even yourself to address. So you are a party. You are a party. That one I can assure you.
My lord, we were not entitled to the right of joinder, and we had points that we wanted to defend against the respondent side. So we're just finding it very difficult that due process is not being followed in our instance, as we applied even before both parties on the 8th of October 2024. They came to court on the 18th, 10 days after us, and they have still been granted audience before us, and we were told we're going to be in cohort 1, and then cohort 1, this application has already overtaken cohort 1. We're now being told to come next week, after the swearing in would have been gone through, and after numerous rights would have been violated that we have raised.
I think, Ms. Wanjiru, what you just need to do is just get into the CTS, get all the directions. There's every direction. There's a reason why we came up with cohort 1 application petitions and cohort 2 applications.
Yes, my lord.
So I think we may not wish to respond on whether you are discriminated or not, but we are so sure you are not discriminated, because there are proper directions in respect of every cohort and every matter before us. Kindly take time to go through the CTS.
Yes. My lord, thank you. This court had made directions on this issue. We said there are only 2 applications before this court right now, and those are 2 applications which will be responded to. We have applications. We are finished with this side.
You have not spoken on behalf of the second petitioner.
My Lord, that we would like an opportunity to respond to both applications that are being brought today.
Maybe I can say one thing, just on behalf of the second petitioner. My name is Kimotho Teresia Wanjiru Makazi. Yes, there's Kimotho in company advocates Kerugoya. I just wish to say we welcome the ruling. However, there are some bits that we feel aggrieved and we wish to appeal. And therefore, as we do the notice of appeal, we are praying that we are in support of the issue for injunction, no the issue for stay, which the court may say it's a negative order, but we are saying pending the time we do the appeal, at least the status quo be maintained. And also we wish to say that there was an issue that the Court of Appeal today, application for stay, that is not true. We were told to serve, parties were not all served, and that's the reason why we were given another date. So therefore we are in support of these two applications that have been made today. Thank you.
Let's Wanjiru also. Mr. Dr. Bosso, please sit down. Please sit down.
My Lord, this
court. Please sit down. Please sit down.
Will I be given a chance to speak?
Please sit down. Ms. Wanjiru, proceed.
Yes, my Lord. As a young woman, I'm under 35, my Lord. I'm actually 35. I'm a youth and I have a disability. And we're the only ones, I think, on the platform that check that we have a disability, my lords and my lady. Our Constitution, Article 1.1, has to count for something, because it was intended for us to come to courts directly.
Please respond to the application. Support, make the application.
Yes, my Lord, I'm in support of the application. Mr. Vice.
My Lord, finally. My Lord, in response to the two applications, yours also an application. Yes, my Lord, in response to the application by my learned friend, Mr. Ochiel, future senior counsel, and my learned friend, Mr. Ndegwanjiro, I wish to set as follows, my Lord. My Lord, number one, the Matthew paper order sought by my learned friend fall on the basis of the following principles. Number one, my Lord, there is already an appeal that has been filed in the Court of Appeal, and an application for stay under Rule 5 to be filed, being application number 554 of 2024. The Court of Appeal is therefore seized of this matter, already seized of this matter. In those circumstances, my Lord, a party can only apply for stay in the Court of Appeal. That's point number one. My Lord, point number two, ordinarily, when a court delivers a ruling in a matter, the court becomes functus officio in respect of that particular matter. My Lord, that matter therefore, or the applications made are therefore res judicata, in the sense that a determination has been made, and this court cannot go back and approbate and reprobate at the same time. You cannot deny an order and then purport to issue the order again. Point number three, my Lord. My Lord, rules 23 and 24 of the Mutunga rules as presented before you, together with an application by my learned friend on substantive issues touching on actions that may be undertaken subsequent to this, including, my Lord, the qualifications of the Deputy President nominee, Kithure Kindiki, can only be brought to this court, my Lord, through one, either a new petition and a new application, or two, my Lord, through an application for review. The only avenue that Mr. Ndegwa can bring all the issues that he has spoken to this afternoon are applications through review. No application for review or setting aside has been filed before this court by Mr. Ndegwa. And therefore it is inconceivable, my Lord, that this court would entertain the application brought on several grounds, my lord, including grounds challenging the suitability or otherwise of the Deputy President nominee. My lord, lastly, and because my learned friend will submit further, once a court has delivered a ruling, my lord, the justice of the cause is that consequential processes can be undertaken given that there are no orders in place. And that is not for the court to be part of or to control. That is for other parties, probably not before this court, my lord. My lord, what you have done is dismissed the application conservative order. So that's a negative order. The court cannot be invited to review or to stay a negative order that has dismissed an application. And the negative order again goes to the application by Kimotho and Company Advocates from Gachagua'S, who has also sought to stay your orders, yet all that application had, my lord, was for the former Deputy President, former underlined, to apologize to NIS. Surely, Kimotho, you can do better. My lord, I'll invite my learned friend to go.
You are protected. You are protected.
No, Mrs. Kimotho and Company.
Yes, my lord, my name is Muzomi Nkolu for the second interested party. I have listened very keenly to the two applications, and the issues for you to weigh in your mind are as follows. One, if the outcome they seek through these two applications was declined by the Court of Appeal, not yesterday, but today morning, can this court, being a court lower than the Court of Appeal, on the very same day be seized of an application that result in the very outcome?
Lordship, may I kindly bring it to your attention that counsel has a duty to this court to speak the truth. Being an officer of this court, being a doctor and a teacher of the law, he understands the duty that he has towards you and towards the law, and the fidelity to the law. It is not true that an application was dismissed. It is true that parties were told to serve. So let him submit on the premises of facts and not the premises of presumptions and with the intentions to mislead this court. And if it was declined, let him bring the orders.
My lord, I think it's an issue of semantics. I come from a community that is not an expert in the English language, but whatever you call it, the point is this. The effect of you granting either of the two applications would be to contradict a decision by the Court of Appeal today morning, not to grant similar applications. That cannot be denied in good faith.
We are objecting to this. They are misleading. I was before the Court of Appeal.
You were in a car. You were in a car in the morning.
My lord, the Court of Appeal is a court of record. I don't want to belabor this point. Let me move to my next point. The Court of Appeal is a court of record, and I'm sure the court has access to that record. Two, my lord, it is not like Kindiki was nominated yesterday or the day before yesterday. He was nominated several days ago. If the applications now being made were made in good faith, they should have made a formal application several days ago, which would have been on record, which we would have had the opportunity to respond to. You are now being invited by submissions from the bar without a formal application to grant some relief, supposedly on the ground that Kindiki is unsuitable. That cannot be proper, my lord, especially when the nomination of Kindiki wasn't made yesterday or last night. They had noticed for several days. If they have any issues with the suitability, they would have filed an application on that regard, or even amended the applications we just determined, and they were granted that leave, and they didn't amend them. So surely it's an ambush for my colleagues now to stand up and start telling you Kindiki this, Kindiki that, and therefore stay, and therefore Madhu paper this and that. 2. Number 3, my lord. What you're being asked to do is to flip-flop or to behave like a pendulum. My lord, a pendulum moves from this end to the other end, but it never leaves the two extremes, so there is what I usually call motion without movement. The court has already read a ruling to us saying that it cannot issue a conservatory order that would have the effect of suspending any provision of the Constitution. You're being invited right now to do exactly what you have just told us cannot be done, and you're told the reason you should do that is because you're human and there is a possibility you're in error. Of course there is a possibility, my lord, you're in error, but there is a court that exists to correct errors made by this court. You're being asked to embarrass yourself to say just a few minutes ago that the conservatory order should not have issued in the first place, and then you're being invited to issue an order that would have the contrary effect. I think they are setting up the court for embarrassment. My lord, there is a reason, there is a law which we all know because both the people in the bench and the bar are lawyers. And it is common ground that no appeal operates automatically as a stay of any decision made by any court. The reason that rule exists, my lord, is so that whoever is desirous of an appeal can move the appropriate court, which they have done, and persuade that appropriate court to issue that stay. So they are telling you because there is a possibility you might be in error, therefore automatically, but the rule, if I understand it, is that no appeal, let alone an intention to appeal, can issue automatically. Lastly, my lord, you have been told about a Madhu paper, injunction. I thought we were talking about conservatory orders, my lord, because Munya told us injunctions are remedies in the realm of private law. They exist to protect personal private interests, and conservatory orders, which you just said cannot issue in the circumstances of this case, are the remedies available in public law for the ordered functioning of public agencies. And because, my lord, I said this court has jurisdiction, if eventually you find that the Honorable Brigadier Gachagua'S was not lawfully impeached, this court has still confirmed it has a remedy. It can undo the entire process. Let us not detain you here, back and forth, flip-flopping, behaving like a bedlam. It is holding the court at ransom, in my view.
My lord, if I use only 2 minutes in rejoinder, the court permit me.
You will respond after Peter.
Yeah. My lord, I'll just take 2 minutes to mention something which will be in addition to our case. My lord, Article 10 of the Constitution outlines the doctrine of rule of law. My lord and my lady, the doctrine of rule of law anticipates that at some point controversies in the society, especially legal controversies or controversies related to the interpretation of the Constitution, will be determined by judges. And concomitant to that is the doctrine of finality of your decisions. And more importantly, the public policy in terms of consistency in judicial decision making. So that, my lord, my lady, once you've made a decision, the expectation of the public is that you will stand by that decision unless there are exceptional reasons for you to depart from that decision. especially immediately after you've rendered your decision, it will undermine that doctrine of finality of judicial decision making. If you immediately depart from the decision without exceptional reasons, they have not put on record exceptional decisions to warrant that immediate departure, and the public expects that your decision will be enforced. Secondly, the doctrine of rule of law again operates in a complete way. John Locke in 1689 developed a concept in his treatise of government known as the concept of inalienable right, which informs our constitution. And one can mention here that judges have a right to be wrong. They say you have a right to be wrong. We have listened to your decision, and we believe that the reason why conservatory orders cannot be continue is a heavy public interest reason of the need for the vacancy, for there to be no vacancy in the office of deputy president, and the constitution does not anticipate that. So in conclusion, they, under the provisions of Article 164(3), they, based on the way the rule of law works to model the fabric of the society, they have the right to appeal. My Lord, you have granted that right in your ruling. And from where we stand, we submit that they cannot, on this matter of immense public interest, where you've made a decision for them to seek, to make an application from the bar, to upset a decision which you have rightly pointed out is meant to fill a major constitutional gap in respect to vacancy. And lastly, the right to be heard. The right to be heard is very central. Mr. Ndegwa has made factual statements in this matter in his oral application. Again, given the immense nature of this matter in terms of public interest connotations, it is important that the respondents are given opportunity to specifically rebut the factual questions of law, the factual questions and some of the legal points that they are brought up. So in that case, if they really want to move this court, then we will submit that the proper way is to make a formal application so that we are hard on that question. Thank you.
Your Lordship, the IEBC, the second application was directed at us. Everyone seems to have said something except the IEBC. And I just want to make two small points. Number one, as it relates to the application by Mr. Ochiel Dudley, my friend. First, Madhu paper was pre-2010 constitution. That is important for the court. It was a commercial matter relating to restitution. So it was a remedy in private law, not in public law. Lordship, Madhu paper was pre-2010 constitution. It was a commercial matter, a restitution in private law. So this will not apply. The second issue, application by Mr. Ndegwa, Learned Counsel, I am looking forward to reading the decision of the court, because those were issues that we were on our feet for 30 minutes arguing about, the role of IEBC and what needs to happen. So already the court has made a decision on that, and likely the answer will be in the ruling that the court has already read. Third one, and most importantly, I want to point to the court the case of Eliud Matindi and two others versus the President of the Republic and the PSC, E084 of 2023. It is the CAS matter. And it feels almost like deja vu that Ochiel Dudley is here making this point. We lost that matter in the High Court. The court made a finding that the offices of CAS were not constitutional office. We were on our feet for a long time trying to urge the court to give us a Madhu paper injunction. And the court said, if the issue related to constitutional compliance or constitutional infraction, as the court has already noted, that the position of the Constitution must remain operational from the decision of this court, then that injunction will not apply. The remedy is for the parties to apply to the Court of Appeal for an appeal or a review of that decision. So those three things can clarify those two issues for the court. We think these applications are not merited, and the court and the parties should put more effort in their 5-2B application. Thank you.
Perhaps before Senior speaks, maybe we get directions as to how many they are responding, because there was that limitation on this side, and we were restricted as the petitioners. If the court could give directions as to that.
Let Mr. Moses speak.
Thank you, my lord.
My lord, you have not given us directions as to how many of them should address you, considering that the petitioners were restricted.
We said 2. 3 of them have already spoken.
My lord,
Mr. Moses, nothing stops you from saying that you adopt the position of your predecessor.
that's correct.
Yes.
My lord, I want to say that I associate myself with the sentiments by my colleagues, but I would want to add, my lord, that you have given a detailed and a very comprehensive analysis of your ruling. You've gone into graphic details, and you have addressed various issues and given a determination on the same. We are not before this court, my lord, to litigate in installments. My learned colleague, Mr. Ndegwa, has all along been aware that Professor Kindiki was nominated. For him to just spring up now and start raising issues concerning Professor Kindiki is just but a mockery of the justice system. My lord, you've made a determination. You have thanked us official. We will not want you to reopen these proceedings again. They have known and available avenues to them. Let them proceed on those avenues. I submit, my lord.
Thank you very much. On only one point, which I actually objected to when it was being made, the point was that how would Kenyans receive the decision? I'm not so sure whether this is what these applications should be based on, because whichever way, there will be parties that will be aggrieved by the decision. There are many others that will be satisfied. Do not be misled that there would be protests, just the way I also cannot mislead you by saying there will be jubilation and celebration everywhere. The position remains, the court has rendered itself in a decision, the court is thanked us, and therefore we have now to move on. Any party aggrieved knows what to do, which is either to appeal, apply for a review, variation, or whatever it is they have to apply for. If the processes that will take place after this would be contra the Constitution, every party knows what to do, and this court is still seized of the matter, and they will be coming over here for a pronunciation on what the constitutional rights are. Therefore, we should actually not be taking the route that the decision may be popular or unpopular. It's a decision of the court, and it cannot be challenged along those lines.
Thank you. My lord, honoring the court and my colleagues' time, this is my rejoinder in exactly 2 minutes. My lord, Rule 32.2 of the Mutunga rules allows us to make this application informally as we make it. Rule 32.2 of the Mutunga rules allows us to make a Madhu paper application as we do. It says the application can be made informally immediately after delivery of the judgment. Rule 32.2 Mutunga rules. My lord, this president, the Attorney General, when on the other side, has many times sought a Madhu paper injunction. In the Finance Act litigation, where my friend Mr. Somane was present, Justice Majanja presiding, this court in this room issued a Madhu paper injunction. My Lord, on the last point, my learned friend Mr. Joinder sounds familiar with the Madhu paper case. It's a Court of Appeal decision. And you saw the first one, Butt versus Rent Tribunal. It is one of the most cited cases on the question of stay. And in that case, the Court of Appeal said, my Lord, allow me to read, and then I'll sit down. There is no inconsistency in granting such an injunction, a Madhu paper injunction, after dismissing the motion. The purpose of the order is to prevent the Court of Appeal's decision from being rendered nugatory, should that court reverse the High Court's decision. The respondents concede that you could be wrong. There's human infallibility. The purpose of the request we make is to respect that issue. What if you are wrong? And you allow the wrong person to come into the high office you've just established. My Lord, allow the request for 7 days. Thank you so much, my Lord. And my Lord, may I just clarify that our application is distinct. We do not seek stay, we seek an injunction. Thank you.
And I'm interested in the event, my Lord, if it's allowed, can we also move you again to remove it?
My Lord, I think in view of Article 50, they also have a right to make that application. Your Lordship, allow me to draw your attention to Article 149, Clause 1. That London is not burning, and that a vacancy is contemplated, and actually a vacancy of 74 days, within which due process ought to be initiated to ensure that a rightful person, fully qualified, fully known in law, fully appreciated by the law, takes over office. Therefore, this vacancy is a constitutional vacancy. Further to that, Your Lordship, permit me to address you that this is a new application and this application has not been determined. Further, allow me to indicate that I listened pensively to the 3 thematic issues that were raised by the court, and this is not one of them that was raised and resolved by the court. Finally, Your Lordship, we all have a duty to uphold the law and to defend the Constitution. On the 16th of October 1953, Fidel Castro had this to say in his defense, that history will absolve me. History will absolve the petitioners. That we have brought to your attention that you have the duty to protect the Constitution, that the person qualified should take over. I'll wait for the ruling. Finally, Mr. Somane has not addressed you on the qualification and the ability of a person to meet those qualifications under Article 99 and Article 137. He has not even told you that they are not applicable. If the court wants to say they are not applicable, history will absolve me. If the court wants to say that it has no power to defend the Constitution, history will absolve me. If the court wants to pave way and mutilate this Constitution, history will absolve me. If the court wants to midwife an injustice, history will absolve me. I am most obliged.
My Lord, Sam Nyaberi for the 9th petitioner. Only 2 issues. I invite you to Article number 23 of the Constitution, which gives parties a right to come before you. Article 23 of the Constitution, which allows parties to come before you to seek for reliefs. And in this instance, we are seeking an injunction by way of a stay, albeit temporarily, of the orders that this court has issued. And we are not seeking these orders in eternity. We are moving into the appellate court once we have the ruling. Number 2, my Lord, I invite you to the application by the 9th petitioner, the notice of motion application dated 18th of October. Because there was an allegation that we have been sitting here and it's coming as news that Professor Kithure Kindiki has been nominated to take over the DP position. My Lord, that notice of motion application speaks to the application they were making, that it was seeking for a conservatory order, and the court has rendered its decision. So we are inviting you kindly to exercise your discretion so that we may have that application processed before the appellate court if it is found of merit, so that we don't have to have it as an academic exercise. Thank you, my Lord.
May it please the court. My name is Dr. Iboso, and my co-petitioner had made a similar application that the Honorable Court be pleased to stay the order that it has given today. And the respondents have raised an issue that Professor Kindiki was nominated over a week ago, and that if we were raising this application in good faith, then we ought to have raised it earlier. I wish to refer the court to its directions, which made it clear that one, the only applications it was going to hear were the two applications that were before the court, and this was made despite protests that my co-petitioner and I have raised for the last 2 weeks, that we have applications that seek similar orders and they've not been heard. However, I also would wish to direct the court to its own directions, which directed that we file amended petitions because many of the petitions had been overtaken by time. And if you look at our petition as amended, we actually raise concern about the process of election of the deputy president designate in our amended petition. And so it is quite in substance and whatnot. Secondly, I'd like to point out that my co-petitioner pointed out that we have been feeling discriminated. And as she explained earlier, she's dyslexic, and sometimes she might rush her words, especially when she's tense. The feeling of discrimination that we've been having is that out of all the petitioners, we are the ones who have consistently for the last 2 weeks called on the court to refer to the applications that are before it, and that which touch on this, and will be given adequate time to ventilate them. Yesterday, I agree we were given an opportunity to speak as interested parties, and after the respondents gave their case yesterday, I tried to catch the attention of the court, and I was ordered to sit down. I wasn't rising because I don't know I don't have a right of response. I know that. I was rising because I sought the discretion of the court, specifically because there are specific 4 issues that the respondents raised against the things I had raised. And in the decision of the court today, which I have listened to, one of the issues has actually turned on that. The fact that this court believes, which I believe is wrong, that it has jurisdiction to reverse the assumption of office of the deputy president. Of course, you've given your ruling and we respect it, and we wish to appeal that ruling. However, now we are asking the court, because both the respondents and us applicants agree that we have moved the Court of Appeal, and the Court of Appeal has given a mention date. So the court is aware of that, or at least that is not disputed. We are asking the court to stay its decision today, allow us to move the Court of Appeal appropriately so that it can give the necessary orders as relates to that, even if it means correcting what we believe to be the wrong finding of the court. The idea that this court is functus officio does not arise, because the rules of the civil procedure, I'm not sure which rule exactly it is, allow any court, after giving its judgment, allows a party to ask for a stay even informally and the court to grant it. So really, the issue of functus officio does not arise. Thank you very much.
Thank you. We will adjourn for 20 minutes. We'll be back at 5:30.
The mountain loses nothing. There is some